Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello, and welcome to SCOTUScast. I'm your host, Kyle Hammernes, on behalf of the Faculty Division of the Federalist Society. We are here today to discuss United States v. Rahimi, which was argued before the court on November 7th. It is my honor to introduce our guest today, Mark W. Smith. Professor Smith is a presidential scholar and senior fellow in law and public policy at the King's College. He is also a visiting fellow in pharmaceutical public policy and law in the Department of Pharmacology at the University of Oxford. Additionally, he is a constitutional attorney and host of the Four Boxes Diner YouTube channel, which provides scholarly and historical analyses of the Second Amendment. And with that, I'll hand things over to our guest.
I appreciate that. So we had about a 90-minute oral argument, started at 10 a.m. What's interesting about the Second Amendment argument is that the government had to go first, because usually over the years, it's those that support the right to keep and bear arms that keep losing in the lower court. So it's highly unusual that we had a situation here where the Second Amendment advocates, if you will, the person advancing the Second Amendment, actually prevailed in the lower court, specifically in a 3-0 decision in the Fifth Circuit Court of Appeals out in New Orleans. Was a decision that said that the relevant federal statute here, which is a gun control statute, 18 U.S.C. or 18 U.S. Code 922 G8 was unconstitutional on its face, is what the Fifth Circuit said. Specifically, what 922 G8 says is that if you are subject to a civil, and that's key, if you are subject to a civil domestic violence restraining order, then you are not permitted under federal law, as per Congress, to be able to possess a firearm anywhere in the United States. And mind you, just to give you a sense of the scope of this law, if you, let's say, are in a dispute, let's say, with an ex-spouse or with someone you're going through a divorce with, whatever it is, and let's say Boston, Massachusetts, and there is an order entered that says that you two are supposed to stay away from each other during the pendency of the divorce, and you go ahead and move all the way across the United States to Phoenix, Arizona, thousands of miles away from your, ex-spouse or the person you're going through a divorce with, or whatever it is, ex-employee, whatever it happens to be, then under 922 G8, you are not allowed to possess a firearm, even though you're thousands of miles away from the person who's also subject to that domestic violence restraining order. And the only other context I want to bring is one of the other things that was raised in the amicus brief and actually mentioned in oral argument is many times these domestic violence restraining orders are mutual. And what that means is that they basically apply to both parties. And as you know, sometimes one party may be more dangerous than the other party. Nevertheless, for the good of the order, it's not unusual, and this was brought up by many amicus briefs, I believe also by several public defender offices across the country, that both parties are basically disarmed, and that might be the case where a person who's a potential victim is disarmed as much as the person that might be the potential perpetrator. And I should note that that played a big role, as I see it, in the Fifth Circuit's decision that says that 922 G8 was unconstitutional under the Second Amendment. Now, with that context in mind, let's talk about what happened, what I think is going to happen, and then where I think all this goes. To begin with, to cut to the chase, it's in my opinion that Mr. Rahimi, the man, the criminal defendant, is likely to lose this case. I suspect he's going to lose this case. It could be as much as 7-2, 8-1, possibly even 9-0. It's hard to say for sure, but I think that Mr. Rahimi himself is going to lose this case because at the end of the day, the Department of Justice, when they were arguing this, bear in mind that in the briefing, and this is quite interesting, in the briefing, the Department of Justice argued there was really two types of people that legislators, such as Congress, can disarm in America. One category are those that are not law-abiding. The other category is those who are not responsible. And what the Department of Justice argued in their briefs in the Rahimi case was that if you were not responsible and or you were not law-abiding, you could be disarmed. Now, that argument that the Department of Justice advanced, and remember, again, reminder, the Department of Justice spoke first. The Solicitor General, who did a great job, as she always does, spoke first. And what's interesting, in literally the first few minutes, Chief Justice John Roberts immediately quizzed her on this by saying, well, let me get this straight, counselor. If I drive 30 miles per hour in a 25 mile per hour speed limit zone, have I somehow basically lost my right to keep and bear arms because now I'm not law-abiding, I'm not responsible? And immediately the Department of Justice, and I think this is going to be actually a potential problem for DOJ in future cases, she immediately conflated her position and said, no, not true. Really, at the end of the day, it comes down to whether or not you, as an American citizen, are dangerous. Now, what's quite interesting is people then, the court then kind of said, well, that's interesting because, you could have just said that in your briefs and said, dangerousness was the touchstone here. And basically the Department of Justice, the Solicitor General kind of said, well, yeah, dangerousness is really the key. Yes, we agree, but there's different ways you can kind of get there. And at the end of the day, the court should always defer, as I see it, this is what they argued, to defer to the legislative body, in this case, Congress. So with that said, I do think that a comment by Justice Neil Gorsuch was telling, because once Chief Justice John Roberts made the comment that got the Department of Justice to concede that really dangerousness is the key issue, meaning if you are dangerous, i.e. a physically violent danger to yourself or to someone else, then you can be disarmed, which is really where the questioning from Chief Justice John Roberts took the Department of Justice. Justice Gorsuch then sort of followed up and basically indicated that, hey, well, if that's the case, then here it seems to me that, the record is such that Mr. Rahimi seems to be dangerous since, of course, he admitted and consented to the entry of this restraining order. And if you look at the terms of the restraining order, it's essentially conceding that the affidavit submitted by Mr. Rahimi's ex-girlfriend, I believe it is, said he was violent toward her in very specific ways. He consented and agreed to the sworn statement and consented to the entry of this restraining order. It seems to be at that level, he may very well be deemed dangerous. And then on a related note, Justice Gorsuch went on to indicate that there seemed to be plenty of history at the time of our founding, such as surety laws and also affray laws, that would indicate that someone who is a violent danger to themselves or to others could be disarmed. That did not seem to be a particularly controversial proposition. So where a lot of what happened here in the oral argument was the Department of Justice under Merrick Garland and the Solicitor General, of course, trying to broaden the scope of the interpretive methodology of Bruin. And this was a very big deal because from the point of view of the Second Amendment community, those interests were concerned, I would say, that because Mr. Rahimi himself, Mr. Rahimi the man, had a record, at least based on the court filings, that he was somewhat of an odious character. He had been involved with multiple shootings. He had engaged in violence against his ex-girlfriend and had done other things that were untoward. I think there was even allegations that he might have been connected to the drug trade in certain respects. So on this record, obviously, the man, Mr. Rahimi, did not look particularly good or sympathetic. And I think there was concern on the part of those that want a robust or broad interpretation of the right to keep and bear arms, that this particular case could be a problem in the sense of bad facts could make bad law. And I think the flip side, of course, was that the Department of Justice under Joe Biden, that obviously is sympathetic as a general matter to more gun control, I think that's fair to say, that the Solicitor General basically was trying to expand the scope of those types of people that could be viewed as able to be disarmed. And on a related note, was trying to expand the scope of historical analog laws that could be used to justify modern day gun control law. And I'll get to those specifics in just a couple minutes here. So with that tension going on, I would say Mr. Rahimi will lose this case. There will be a holding that 18 U.S.C. 922 G8 on its face is constitutional. However, so at one level, Mr. Rahimi is not going to be happy. But then the question becomes, is when the decision comes out, how will, let's say, the Biden administration view the outcome of the case favorably or unfavorably? And how will, let's say, the Second Amendment community view the case favorably or unfavorably? Here's where I think it's going to come out, and then I'll elaborate on the range case, which I think is coming down the pike. I think the Department of Justice is going to view this as a missed opportunity. I think they thought this is a very strong case for them to, again, have bad facts make bad law. And I think that they were very excited at the prospect of pushing this Rahimi case to the front of the line of Second Amendment cases before the Supreme Court. Because historically, Second Amendment cases that are brought before the court tend to be very sympathetic toward the citizen. Heller, you had an individual that was a former law enforcement officer who could not get a handgun. McDonald you had Otis McDonald, an individual who lived in Chicago in a crime-ridden area, could not get a handgun, a sympathetic Second Amendment plaintiff. In the Caetano versus Massachusetts case, you had Jamie Caetano, a woman who had been stalked by an ex-boyfriend and needed to use a stun gun to protect herself. And of course, in Bruin, you had individuals that were undeniably upstanding citizens that just wanted to carry a gun for self-defense when they could carry a gun for all other reasons, but for self-defense. So in every single one of those Second Amendment cases, we saw the citizen was very sympathetic. So in this instance with Mr. Rahimi, his background and the allegations in the record, he obviously was nowhere near any of those other individuals. So I think that, again, the idea being this was a very good case to really test what's known as the Bruin methodology of interpreting the Second Amendment, which is the text first and historical analog law second. I think the idea on the part of the Department of Justice was that to make sure that individuals like Mr. Rahimi cannot go free, the court might bend over backwards and loosen or water down the interpretive methodology of Heller and Bruin, of text first and historical analog second, that methodology. But I don't think it's going to work out that way, because it would seem pretty clear that the justices thought that it was a very straightforward case, that if you are a danger to society, you can be disarmed, that there was a lot of examples of this going all the way back to the time of the founding. So it doesn't appear to be a particularly controversial issue here. On a related note, it seems to be that the U.S. Supreme Court is not going to get into some of the natty little questions that can come up in these cases, because it sounded as if they wanted a narrow ruling here. They would simply say that on its face, 18 U.S.C. 922 G8 is constitutional under the Second Amendment. But I think they're going to write something in there that says, hey, but nevertheless, there's a lot of defenses that could be raised in future criminal cases involving this. Commerce Clause arguments that says that Congress lacks the authority to enact this kind of local domestic law enforcement statutes. You can see due process arguments. In fact, I should note that several times due process came up. What process was afforded to Mr. Rahimi in the context of the procurement of the state domestic violence restraining order that arose out of the state of Texas? And at the end of the day, I think Justice Barrett really hit the nail on the head, where she's basically saying, look, you didn't argue due process down below. Your client consented to the entry of this order. The order specifically says he's not allowed to have a gun, and he signed off and swore to it with a notary. And there was a sworn affidavit that he didn't challenge or disagree with. So it seems to me the due process is a legitimate issue. And I think the court acknowledges it is a legitimate issue, but it was not really preserved in this case. So I think they're going to say that although the statute is going to be upheld under the Second Amendment, there's a whole lot of as applied challenges that can be brought against the government on behalf of American citizens in various ways. Now, from the perspective of the expectations of the Second Amendment community, I think there, again, was a lot of concern that the Supreme Court would use this case to water down or possibly even reject the Bruin methodology. But it's pretty clear that's not going to happen. And I think that one of the best tells about this is a comment made by Justice Barrett about the Bryan Range versus Garland case, which came up today. Now, the reason why I bring up the Bryan Range versus Garland case is because it is the case that the Third Circuit Court of Appeals en banc issued a decision that says that Bryan Range, who had been prohibited from possessing firearms under a different provision of 18 U.S.C. 922 G. Keep in mind that gun control statute 18 U.S.C. 922G is the list of prohibited people. It includes people like those subject to domestic violence restraining orders. It also involves felons. That's 922G1, those that have been dishonorably discharged from the military, those that have been involuntarily committed to a mental health institution, and so on. So that's what 922G is. So what's interesting is this, and I think this is quite telling. Justice Barrett made a reference to the Range case. Now, the Range case, as we sit here, is up on cert. It's up on a cert petition. The Third Circuit entered an order that said that Brian Range, a nonviolent felon who was convicted something like 20 to 25 years ago of failing to disclose something like $500 in income on an application to the state of Pennsylvania's welfare program to collect food stamps or some sort of welfare, and that he failed to disclose that income. That was, he pled guilty to fraud by not disclosing that. And as a consequence, because of the penalties that were potentially applicable under that statute to Mr. Range, he qualified as a felon as that term is defined by 18 U.S.C. 922G1. So he lost his gun rights. He brought a lawsuit under the Second Amendment, applying Bruin, of course, saying that he's entitled to his right to keep and bear arms because there's no historical analog law at the time of the founding that says that nonviolent felons or anyone that's nonviolent could be disarmed permanently. And the Third Circuit agreed with Mr. Range and says, indeed, with respect to Mr. Range himself, because there's no evidence of dangerousness or physical dangerousness or violence or anything along those lines, we, the Third Circuit Court of Appeals en banc, agree that Mr. Range is entitled to have his Second Amendment rights, and 18 U.S.C. 922G1 is unconstitutional as applied to Mr. Range. Now, the reason why it's very important to understand this Range case in conjunction with the Rahimi case is that both of these cases were available for the Department of Justice to seek certiorari this spring. And just the Department of Justice decided to push the Rahimi case first, and they waited until just about, a month ago to seek cert in the Range case. Even though many commentators, including myself, pointed out that the Range case was much more typical situation and is the case that the Supreme Court should take and is the case that the Department of Justice should push. And the reason why that's the case is if you look at the number of prosecutions and convictions every year, under 922G1, dealing with felons in possession, it is literally thousands and thousands of people every year get caught up in 922G1. In contrast, the Rahimi case speaks to 922G8, and there's only something on the order of magnitude of 15 to 30. That's 15 to 30 convictions every year under 922G8. So it's rarely used. And I mention this because it is pretty clear from Justice Barrett bringing up the Range case, even though cert has not been granted. And the Range case, I should note, is coming up for a conference before the Supreme Court on November 17th. It's coming up in just a couple of weeks. So I think it's quite telling that the U.S. Supreme Court is focused on this Range case. And I could see a real scenario where the Supreme Court grants cert in a few weeks to the Range case, and we see two Second Amendment cases in this term dealing with 922, one 922G1, the Range case, and 922G8, the Rahimi case. And now one might say that that Range case could be held pending the outcome of Rahimi, and that would have been true up until this morning's argument. And this is another example where I point out that it's strangely enough that although going into this argument, I think the Department of Justice was optimistic about what the Rahimi case could do for their gun control agenda. And I think the Second Amendment community was concerned about what the Supreme Court might do with the Rahimi case that could cut back on Second Amendment rights. I actually think it may now backfire. And the reason why I say this is because in a colloquy between the court and the Solicitor General, trying to understand how the Department of Justice went from their papers being that people that are dangerous and unusual cannot have guns to, I apologize. In the briefs, they were trying to say people that were not law-abiding or not responsible could lose their gun rights to dangerousness, and how this got morphed in the context of the oral argument, the Solicitor General tried to explain it away by saying, well, what we're really getting at, Your Honors, was in our brief, we're trying to say there's two buckets of people that can be disarmed by Congress or by the legislature. The first bucket are those that are not law-abiding, and those are people that are convicted of a crime. And then the Solicitor General said, but there's a second bucket. That other bucket are those people that are not responsible. And the distinction that I think that the Solicitor General is trying to make here, and argued it, but you'll see why I think it's going to backfire in 1 second. She was arguing that the Rahimi case is an example of the latter category, where if you are not responsible, we can take away your guns even if there's no criminal conviction. Because keep in mind that the 922G8 prevents you from having a gun even if you are not criminally convicted. The domestic violence restraining order is a civil process, and that civil process gives rise to denying your right to keep and bear arms, which, of course, the Supreme Court has repeatedly said is a fundamental right on par with other fundamental rights. So the interesting thing is the Department of Justice has taken the position that the Rahimi case falls into the bucket of those people that are not responsible Americans. And then in contrast, she was arguing that people that have been convicted, who've been convicted of a crime, fall into the other basket of those people who can be disarmed. Those are people that are not law-abiding. But the problem, I think, from the Solicitor General's point of view, and I think Justice Barrett picked up on this, which is why she asked about range, is by delinking responsible people or irresponsible people from law-abiding or not law-abiding people, by creating two buckets there. I think the Solicitor General has basically opened the door for the Supreme Court to take the Range case and the Rahimi case, because now the Rahimi case can be used in this term to clarify what it means to be not responsible, which I think is just dangerous. And likewise, dealing with the non-law-abiding component, which is really the Range case. And I think Barrett sort of signaled that there's a good chance we may see both of these cases this term, which again, I think is ultimately favorable for the Second Amendment jurisprudence to continue to get these cases, because, you know, in many years, we'll see 3, 4, 5 Fourth Amendment cases. We'll see multiple First Amendment cases. We've never seen a Supreme Court term where there's been multiple Second Amendment cases, and there's really no reason why that cannot occur. Now, the other critical thing here, and I just want to remind all of you of the Heller/Bruen methodology. In Heller, the Supreme Court concluded that the District of Columbia's handgun ban was unconstitutional. Now, the methodology of interpreting the Second Amendment that the Heller court did was originalism. And what I mean by that is they started off with the text of the Second Amendment. They defined all the terms of the text of the Second Amendment using 18th century lexicography, dictionaries, or other sources. And then after that, they turned their attention. Obviously, they concluded that a handgun was a form of arm, as in the right of the people to keep and bear arms. So then what they did is they shifted the burden to the government and said, okay, is there any historical tradition in American law of disarming people of these commonly owned handguns? And they concluded, no, there wasn't. And they created the in common use test. But the way the court did it in Heller was, again, they looked at the text first, and then they looked to see, is there a historical tradition that could justify the government being able to regulate handguns in some way? In Heller, it was, is there a historical tradition of banning commonly owned arms? And the Heller court says no. So I mention that because this is a very important point to keep in mind. It's often lost in commentary, which is when people talk about the Bruen methodology, which of course arises from the 2022 decision of NYSERPA versus Bruen. The Supreme Court's methodology of interpreting the Second Amendment is identical to Heller's. It's the same methodology. You start with the text. If the text is implicated by the modern day gun control law or by the conduct that the American citizen wants to engage in with guns, then the text is satisfied. The Second Amendment is presumptively viewed as binding, and the law, the gun control law, is presumptively viewed as unconstitutional. And that shifts the burden. It shifts the burden to the government. No different than in a criminal case where if you're indicted or charged with a crime, you are presumed innocent. The burden shifts to the government to show that you are guilty of the crime. It works the same way metaphorically here. Once the text implicates a modern day gun control law, the burden shifts to the government, and the government has to meet its burden. So this is the critical part of Rahimi cases. I see it. The question is, what is the government's burden? Now, we know what the government's burden is as a concept. Under the Bruen case, it says the government's burden is to come forth with proof of a longstanding, well-established historical tradition going back to the founding of type of gun control law that is analogous to the modern gun control law they're trying to uphold. So it's a comparison of the gun control law in case of Rahimi, 18 U.S.C. 922 G8. You lose your gun rights if there's a domestic violence restraining order. You compare that modern day gun control law with some historical laws going all the way back. Now, obviously, the more narrow the analog that you're looking for, the harder it is for the government to satisfy its burden once the burden shifts to it. The broader, more generalized analog that government is allowed to use to justify its modern day gun control law, the easier it is for the government to win. So a major part of what was happening at oral argument, and you can see this with the colloquy going back and forth between Justice Kagan, Justice Sotomayor, and Justice Brown Jackson, with the Solicitor General and with Matthew Wright, the attorney representing Mr. Rahimi out of the Federal Public Defender's Office. You saw a lot of colloquy on that side of the bench, laser focused on what kind of historical analogs or what kind of history can be used to justify a modern day gun control law. Now, the first thing, and I think this is quite telling, is that I think it was Justice Brown Jackson was concerned, and I think Justice Kagan expressed concern as well, whether or not you actually need a regulation on the books at the time of the founding or at the relevant time period. There can be some debate about the relevant time period. At the end of the day, I think it's correctly the founding, but we don't need to get into that specifically, because the truth is, when you're dealing with a federal statute, which is what we're dealing with in Rahimi, 18 U.S.C. 922 G8 was passed by Congress, you don't need to get into the historical debate of whether or not post-14th Amendment history can potentially be relevant to the meaning of the Second Amendment, because you're dealing with a federal statute. And the Second Amendment, when it was adopted, 1791, applied to the federal government. So you don't need to worry about those 14th Amendment, late 19th century historical analog debates in this context. But what's quite interesting is that, Justice Kagan and Justice Brown Jackson really seemed to be interested in whether or not regulations were needed at all. In fact, this was clearly the position taken by the Solicitor General, where she was arguing, especially in this particular case here, where she said that domestic violence, maybe wasn't really considered as a real problem at the time of the founding, which, by the way, is not true. If you look at some of the amicus briefs submitted in the Rahimi case, you'll see that domestic violence was absolutely frowned upon. There was all sorts of criminal and civil remedies, as well as religious remedies, by the way, to deal with domestic violence at the time of the founding. So to suggest that domestic violence was not considered a social problem at the founding is simply not true. Nevertheless, there was a lot of back and forth about whether or not regulations are actually needed. And one of the concerns I think Justice Brown Jackson really expressed was, well, wait a minute, this seems odd. If there are no regulations, then can't we look to other historical evidence? And I don't know what that other historical evidence would be. Presumably, affidavits or stories by historians explain what they think the history is. But the Supreme Court in Bruen was very clear about the type of history. Specifically, it has to be regulations. And I just want to, because I think this is important, because this is where the fight was taking place, is the meaning of this language here from Bruen, which again is really just an embellishment or a reiteration of the Heller test, and laid out more specifically in Bruen, because a lot of the lower courts were not applying this test correctly between 2008 when Heller was decided and 2022 when Bruen was decided. And this is what Bruen said, and you'll see why this argument became so important. Specifically, they write, in keeping with Heller, we, the Supreme Court, holds that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects the conduct. That's the presumption, right? Shifts to the government. To justify its regulation, the government, in this case Congress, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate, and this is the key, that the regulation is consistent with this nation's historical tradition of firearm regulation. That's what Bruen says. It specifically says nation's historical tradition of firearms regulation. And one of the big issues going on today was that Justice Brown Jackson, Justice Sotomayor, and Justice Kagan were really trying to say that that framework or that discussion of regulation in Bruin is not really fair, that they could look at high-level generalized views of history at the time of the founding or any whatever the relevant time period is to try to glean principles from American history to then in turn justify modern-day gun control laws. Now, again, there's no specific issues along that line in this case, but it's pretty clear what the Department of Justice was trying to do is to try to influence the way the Rahimi decision will ultimately be written, to try to say that, yes, indeed, history outside of the context of actual laws, such as state constitutions, such as the federal constitution, such as common law, such as statutes, that other things other than those things, those historical items can be considered. And because, of course, if you broaden the scope of what can be considered to justify modern-day gun control laws, you'd increase dramatically the odds of modern-day gun control laws being upheld. So let me carry on. So again, that was a big issue, but I don't think it's going to succeed because it seemed to me, based on that comment from Justice Gorsuch, that there were plenty of laws at the time of the founding that said that if you were violent, you could be disarmed. And there not seem to be a lot of controversy on that proposition. So I think we are going to see a decision in Rahimi that says that if you are violent, physically violent, you can be disarmed, at least during the period of time that you are deemed violent, and that 922 is facially constitutional. Now, just a couple other items I do want to flag. Some of the people were wondering whether or not the decision as to whether or not Mr. Rahimi himself is part of the people would occur at the textual level. Because again, as I pointed out in Bruin and Heller, you start with the text of the Constitution. Then once it's satisfied, you shift to the historical tradition of government regulation of firearms in this country. Now, the Department of Justice in their briefs was trying to argue that Mr. Rahimi, who undeniably is an American citizen, that Mr. Rahimi actually was not part of the people, as in the word or term as it's used in the Second Amendment, i.e., the right of the people to keep and bear arms shall not be infringed. The Department of Justice in their briefing really laser focused to say that Mr. Rahimi, by virtue of his conduct, would be pulled out textually from the word the people. But that really did not get a lot of play because I think it's pretty straightforward. If you look at the Heller case and Bruin, they define the people as basically all American citizens and then some, anyone that's connected in any real continuous way with the United States, which obviously includes American citizens, are part of the people textually. And of course, keep in mind that the people is not just found in the Second Amendment. That phrase is also found in the First Amendment and the Fourth Amendment. And I don't think there's going to be any suggestion that if somebody who's violent or in danger or irresponsible and gets pulled out of the people textually from the Second Amendment, they would also theoretically be pulled out of the text of the First Amendment and the Fourth Amendment. And that would be quite shocking to a lot of people that have already been convicted of crimes, no longer have Fourth Amendment rights to assert, the exclusionary rule or arguments against unreasonable searches and seizures. So I think that the argument DOJ made and spent a lot of time on in the brief is not going to go anywhere in terms of Mr. Rahimi is not part of the people. Again, I think the issue will turn on whether or not historically Mr. Rahimi can be disarmed as a matter of the tradition in America of disarming violent people. The other thing, the only other point I'll make here, there were two very powerful arguments that were made in the amicus briefs that I actually think will have real play down the road, but not going to have play here. And it's pretty apparent that it's not going to. One is due process arguments. It's clear that the Supreme Court is interested in what kind of level of due process might be required before you can be deprived of the fundamental right to keep and bear arms. Obviously, we know in the context of those people that are mentally ill and are involuntarily committed, there's a whole host of protections associated with that process under what are often known as the Baker Acts or civil commitment statutes. Those require availability of attorneys and experts, and if they can't afford it, they're provided with it by the state. A high standard of clear and convincing evidence, an actual trial, the ability to confront witnesses, and so on and so on. So I think the due process issue is going to play a big role in future 18 U.S.C. 922 G8 cases. But basically, everyone agreed that this had been waived and wasn't really part of the question presented and would not be dealt with in any robust way in the Rahimi case. But look for due process issues associated with Second Amendment challenges down the road. The other thing that I think is very powerful is there was a very powerful Commerce Clause argument using a whole host of precedents saying that there is nothing in Article 1 of the U.S. Constitution that would allow Congress to step in and do what they're doing vis-a-vis these local law enforcement activities, which, of course, 922G8 deals with local domestic violence restraining orders done at the state level or the local level. And I think there is a pretty good argument based on some Commerce Clause arguments that have prevailed in the past, including, for example, the case involving, I think, the Violence Against Women's Act. So I do think we're going to start to see some Commerce Clause arguments against some of these federal statutes. Obviously, that argument would not apply to gun control law enacted at the state level because you don't have an Article 1 problem or interstate commerce argument. But I do think we should keep our eyes on that coming down the pike. And with that said, that is my quick summary.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.